NCLT, NCLAT, High Court as well as Supreme Court. My focus will be on the recent orders, but yes, we'll be taking care of certain past orders which are having some vitalities as far as the recent judgments are concerned. I will be taking care of the matters one by one. I'll be sharing the screen with you. In case of lengthy orders, I will be sharing a brief summary of the order, mentioning the fact of the case, mentioning the issues of law, the fact of the case, issues of law, and yes, how the same was disposed of, or what rationale with which the same was disposed of. So in case if the order is lengthy, in that case, I will be sharing the summary of that said order with you. Otherwise, I will try to focus on each and every order with the arguments of both the sides and final rationale given by the Honorable Tribunal or Appellate Tribunal or Honorable High Court or the Honorable Supreme Court. I'll be sharing the screen and we will be discussing the things one by one. In the meantime, I will appreciate if anything wherein you are not aligned with the thoughts and aligned with the views which are taken by the Honorable Tribunal or Appellate Tribunal, we'll surely have a discussion on the same and then we will be proceeding ahead. So considering the time which is allotted, we'll try to cover up as maximum as possible the judgments which are recently passed by the Honorable Tribunal and Appellate Tribunal. But yes, the focus and the emphasis will be on to cover each and every aspect tendered by both the sides of the litigants. How the screen is visible to all of you?
Yes, sir, it is.
Now, this is a case which is pertaining to the SVA Family Welfare Trust versus Ujas Energy. Now, after a clarity from the Supreme Court with regards to that a creditor, a secured financial creditor on whose favor the guarantee is extended by the suspended management, they may invoke the guarantee. And as far as Schedule 3 or as far as Part 3 of this code is concerned, the constitutional validity which was challenged before the Honorable Supreme Court, but Honorable Supreme Court has made it very clear that the provisions of Section 95 onwards up to Section 100 are constitutionally aligned, and the challenges which were initially made against the constitutional validity of 95 to Section 100 of the code is totally outrightly, it was challenged, but it was settled by the Honorable Supreme Court that is are constitutional in nature, and no flexibilities are given to the respective the guarantor, the personal guarantor of the corporate debtor, from initiation of the insolvency proceedings against the same. But one of the like nature wherein the resolution plan has covered that how the security interest in favor of a secured financial creditor in the nature of guarantee can be covered up in a resolution plan. So I would like to share the order of the NCLT Indore bench, which was challenged before the NCLAT, and NCLT has settled the dust with regards to whether the resolution plan can carry such kind of clause within it through which the personal guarantor can be immune, or the security interest which is created in favor of the financial creditor in the nature of personal guarantee, can resolution plan dealt with such personal guarantee or not, or whether the question of personal guarantee can also be decided by the COC, or whether it shall form a part of the commercial wisdom or not. So this is something which I would like to share first. Now, as far as this judgment is concerned, it is the National Company Law Appellate Tribunal, Principal Bench at New Delhi, In the case of SVA Family Welfare Trust versus Ujas Energy, inter alia held that a resolution plan can contain a clause which extinguishes the security interest, such as personal guarantee, after paying compensation to the financial creditor in whose favor the security interest was created. Meaning, thereby, it is all falling within the purview of the COC to decide whether to approve such a resolution plan which extinguishes such kind of personal guarantee, whether in that case that financial creditor consent or dissent. But if the COC approves the resolution plan with 66% majority votes, then in that case, the NCLT, being an adjudicating authority, cannot sit over the commercial wisdom of the Committee of Creditors. The NCLT further observed that as a consequence, once a resolution plan has been accepted by the COC with requisite majority, in its commercial wisdom, the same cannot be impugned before the adjudicating authority. So this is very clear that the resolution plan can settle the issue pertaining to whether the personal guarantee can be invoked after the approval of resolution plan or not. So brief fact, by an order dated 17 September 2020, the National Company Law Tribunal Indore bench subjected Ujas Energy to corporate insolvency resolution process under the provision of the IBC. SVA Family Trust, that was a successful resolution applicant, pursuant to Form G, submitted final resolution plan on July 2021, read with addendum in August 21 for the resolution of the Ujas before COC. The plan was approved by 78% COC member in 2021, following which a letter of intent was issued to SVA. Subsequently, the resolution professional of the Ujas Energy filed an IA for the approval of resolution plan. So it got approval from the COC and subsequent application was made before the adjudicating authority for approval of such plan. The Bank of Baroda was the dissenting financial creditor in that case, holding only 5.83% shares, filed an affidavit objecting to the approved resolution plan on the basis that plan has provided for extinguishment of the right of secured creditor under personal guarantee agreement. But something which is very interesting, which is coming in, against this extinguishment of the personal guarantee, the resolution applicant has also made a provision of some upfront payment. NCLT passed an order on Jan 2023, inter alia holding that a COC cannot extinguish the right of the secured creditor to proceed against the personal guarantor of a corporate debtor under the grab of its commercial wisdom. So it was the call which the NCLT Indore bench has taken, that COC cannot sit over such an issue wherein the personal guarantee of the corporate debtor is covered up. Such a provision in a resolution plan is not only prejudicial to the right of secured creditor, but is also against the provision of law. So that was the NCLT Indore bench rationale behind rejection of this plan. One more thing which was important in this case, the NCLT Indore bench has noted that the Bank of Baroda had already filed 95 applications against the personal guarantor, which were pending adjudication. In view of the above, the NCLT rejected the plan submitted by SVA on the grounds that plan contain a provision for extinguishment of personal guarantee and consequently contravene the provision of section 30 subsection 2 clause E. But whereupon it was preferred before the NCLET. NCLET has set aside the order which was passed by the NCLT Indore bench. Let's see that. Before the NCLET, SVA inter alia contended that the resolution plan proposed payment of INR 23 crores towards the release of the personal guarantee and as such were to be extinguished upon payment of due compensation to the financial creditor. Relying on the decision of the Supreme Court in Vijay Kumar Jain versus Standard Chartered, SVA submitted that a personal guarantee, more often than not provided by erstwhile director of the corporate debtor, is a security interest under the IBC, which can be dealt within a resolution plan. Further, SVA relied upon the current Urban Cooperative Bank Limited versus Swapnil Bhangardevi, contended that the COC had deliberated and successfully approved the plan. Commercial wisdom of the COC must be given paramount importance and cannot be intervened with at such instance of dissenting financial creditor. SVA also submitted that application filed by BOB under 95 were merely an afterthought since they were filed after the approval of the plan. So COC has approved the resolution plan of SVA, and after the approval of the resolution plan, since BOB was one of the dissenting financial creditor, they preferred the NCLET that the resolution plan ought not to have been interfered with by NCLT since the same had been approved with requisite majority. Further, there is no bar under IBC that restrict the release of personal guarantee from their obligation under the personal guarantee agreement. In support of the impugned order, BOB contested that the resolution plan could not have contained any clause by which a personal guarantee executed in favor could have been extinguished. Bank of Baroda submitted that it was fully entitled to proceed against the personal guarantor to release its dues since payment under the plan does not fully cover its dues. So generally it happens by acceptance of the haircut, they are always entitled to initiate an action against the personal guarantor. But in this very case, the resolution plan was having a clause permitting the COC to extinguish the personal guarantee in consideration of the amount which was given to the BOD in this connection. The only question which arose for the NCLET consideration was whether the resolution plan can contain a clause which propose to extinguish the security interest of a financial creditor by way of personal guarantee. And here the NCLET analysis were, while relying on the ratio of Lalit Kumar Jain versus Union of India to say that the approval of the plan does not ipso facto discharge the guarantor. Now that is settled law. A resolution plan could nevertheless contain a clause by which a personal guarantee created in favor of the FC can be extinguished. And this is very important. That plan could nevertheless contain a clause in spite of the personal guarantor will be held liable even after the approval of the resolution plan, but the resolution plan may also contain a clause by which the personal guarantee created in favor of the financial creditor can be extinguished. The plan allocated a value for the extinguishment. Very important. The plan has also given a value against the extinguishment of the personal guarantee, which was accepted by the COC with 78% majority. COC consciously considered and accepted the clauses in the plan for extinguishment of the personal guarantee of financial creditor for a compensation offered by the applicant for the release of personal guarantee. So there was a separate consideration which was forming a part of the plan, which was to be payable to the secured creditor for relinquishment, extinguishment of the personal guarantee or release of the personal guarantee. NCLET also relied upon its own decision in the matter of Edelweiss Asset Reconstruction Company versus Anuj Jain, RP of Ballarpur Industries Limited, which supports the submission of SVA and held that security interest of dissenting financial creditor by virtue of personal guarantee, security interest of the secured financial creditor, which is given in the nature of personal guarantee, exercised by ex-director of the CD, can be dealt in a resolution plan. Barring BOB, which was only holding 5.83% of the voting share, all the financial creditors of UJAS had assented to the relinquishment of security. The commercial wisdom of the COC in acceptance of the same was to be given a due weightage and should not be impugned at the instant of dissenting financial creditor. So that was a conclusion of the NCLET. In view of the above, NCLET held that the impugned order was unsustainable since the resolution plan submitted by SVA did not contravene any of the provision of section 30 subsection 2 clause E of the code. Accordingly, NCLET directed the NCLT to pass a fresh order for the approval of the plan along with the necessary direction. This matter was again challenged by the BOB before Supreme Court, and Supreme Court has upheld the order which is passed by the NCLET, meaning thereby a resolution plan can dealt with such issues which covers the extinguishment of the personal guarantee, which are given by the corporate debtors suspended management in favor of the secured creditor. And it does very well fall within the commercial wisdom of the COC to dealt such situation, and if the COC approves the same, in that circumstances, the given personal guarantee can be extinguished. So this is one of the judgment. If something is required to be discussed in this connection, we can have a discussion on the same, and we will be proceeding ahead with a very similar nature matter. So there is one more order. Now this is one more case in the same lines with the last order of Ujas Energy. Now this is against the order which is passed by. Now this is in the matter which is in the case the Mumbai NCLT bench was involved. So basically, this is something which is again pertaining to the same, whereas a financial creditor, a dissenting financial creditor, was claiming that dissenting financial creditor, now law is very settled that dissenting financial creditor shall be paid in priority. But there is no provision of the code which states that they will be given a upfront payment. The payment may be paid upfront or in due installment, but it will not be considered as a contravention of section 30 subsection 2 of the code if the resolution plan is having a provision of I said resolution plan is having a provision whether the payment is made by resolution applicant upfront or over the period of time. The only thing which is required to be taken care of is the dissenting financial creditor should be paid in priority over the other creditor. So this is what now this order, which is again pertaining to the same fact which we have discussed. Now this is the case title Puro Naturals JV versus Varana Shahakari Bank and others. So in this matter, again the point of concern was extinguishment of personal guarantee in resolution plan does not contravene IBC rules, and that is the NCLT judgment. Now this is the NCLT New Delhi bench expounded that NCLT, this appellate authority, expounded that the resolution plan providing for extinguishment of the personal guarantee as approved by the committee of creditor, the same facts, did not contravene any of the provision of 32E of the IBC. Now, it was further noted that as per IBC, in the event of liquidation of the corporate debtor, here the plan was approved. Unlike in the earlier case wherein the plan was rejected by the NCLT Indore bench, in this very case, the NCLT has approved the plan. NCLT Mumbai bench has approved the plan, but appeal was preferred by dissenting financial creditor with the claim that extinguishment of the security interest in the nature of personal guarantee is in contravention of 32E. And second point, or the second contention raised by such secured financial creditor was pertaining to whether that dissenting financial creditor is entitled to get upfront payment. And I said there is nothing like upfront, but yes, a priority over the other assenting creditor. It is there in the law. It was further noted that as per the IBC, in the event of liquidation of the CD, the payment to which financial creditor who does not vote in favor of the plan is entitled for the payment in accordance with 53(1). In case of liquidation, it was ruled that no provision in IBC mandate the applicant to make upfront payment to the dissenting creditors. The payment to dissenting financial creditor was given priority. I said this. The focus is on the emphasis on is on the priority and not the upfront. So whether the payment is to be made upfront or over the period of time in due installments, but the focus is on priority. Was given a priority, and whether the payment was upfront or installment did not make any difference. So brief fact, the present appeal arose out of the applications filed by the RP for approval of the plan submitted by Puro Naturals JV and the applications filed by respondent 1 to objecting the plan. NCLT rejected the application for approval of the plan and approved the applications filed by opposing the resolution plan. Now, background says the CIRP was initiated against the corporate debtor on an application filed by ASREC Limited under Section 7. The plan was filed on the basis of inputs of the COC and approved with majority. Plan was filed on the basis of inputs of the COC and approved with majority. It was COC who approved the plan. The successful resolution applicant during the proceedings before the NCLT offered to make full payment. Successful resolution applicant during the process of NCLT offered to make full payment to the dissenting resolution applicant within 90 days of the approval of the plan. The resolution plan, however, was rejected by the adjudicating authority on the ground that plan extinguished the right of the dissenting financial creditor to proceed against. So NCLT Indore rejected on this front. Here the COC has approved. NCLT Mumbai bench rejected on this front that the plan, however, was rejected on the grounds that plan extinguished the right of the dissenting financial creditor to proceed against the personal guarantor, which is very well settled with that Ujas Energy judgment of the NCLT that plan shall not be considered as in contravention of 30 subsection 2 clause E if it is dealing with the personal guarantee of the corporate debtor and if such personal guarantee is being extinguished. Contention of the appellant. It was argued that resolution plan, the securities and the personal guarantee in favor of the FC can also be very well dealt and extinguished. It was further argued that dissenting financial creditor have been proposed to be paid the amount which would have been available to them under 53 in priority of the payment to the assenting financial creditor. Contention of the respondents. Respondents were the one, I said in this particular case, those who have objected to that approval of the plan. It was urged that the payment was not made in accordance with Section 30. Creditors. As per the plan, the payment to dissenting financial creditor was being paid in 3 years, which was in violation of the provision of the IBC. Observation. The issue was whether the resolution plan, so there were two issues. One issue is with pertaining to can plan inter alia provides for extinguishment of the personal guarantee, that is one, and whether the dissenting financial creditors are required to be paid in priority or upfront payment. So that was the point of concern. It was noted that the plan did not envisage the extinguishment of security interest and the guarantee. It was opined that the plan was approved by the majority of the COC and hence could not have been rejected by the NCLT. Same was the case with the Ujas Energy. It was expounded that the plan providing for extinguishment of personal guarantee as approved by the COC did not contravene any of the provision of Section 30, subsection 2, clause E of the code. It was further noted that as per the IBC, in the event of liquidation of the CD, the payment to which the financial creditor who does not voted in favor of the plan is entitled for the payment in accordance with 53(1), which talks about the priority. It was ruled that no provision in IBC mandate the applicant to make upfront payment to dissenting financial creditor. The payment to dissenting financial creditor was given priority. Whether the payment is made upfront or in installment, that does not make any difference. Based on the aforementioned reason, the appeal were accordingly allowed. So basically, it was an appeal which was again preferred by the successful resolution applicant whose plan was approved by the COC, but it was not approved by the adjudicating authority on this very front, that whether the plan can deal with the security interest extended in favor of the financial creditor in the nature of personal guarantee. And the court has made a very clear observation that it is well within the provision of section 30 subsection 2 clause E, and the plan providing for extinguishment of the personal guarantee as approved by the COC does not consider as a contravention of the said provision. And one thing is also made clear that there is no requirement to have any upfront payment, and it is provided that no provision of the IBC mandates an applicant to make upfront payment to dissenting financial creditor. The payment to dissenting financial creditor is required to be given priority, whether payment was made or payment is to be made upfront or in the installment. That does not make any difference. So these are two very similar nature of the judgment which are passed, or which is the viewpoint taken by the NCLAT in both the matter of UJAS as well as in this Puro matter, Puro Naturals JV. I'm coming to the third judgment. Now, this is again very interesting, wherein the RP has moved a suo motu appeal before the Supreme Court. Now, this is Mr. Haribabu Tota, who is a company secretary, and he moved before the Supreme Court in the matter of Sri Ashraya Infracon Limited. I'm sharing the screen. Is this visible?
Yes, sir.
So now this is a judgment, or this is the ruling which is passed by the Honorable Supreme Court. And this is a matter which was preferred by the RP, and it was a voluntary application which was moved, and there was no respondent. And that's why the Supreme Court has taken the viewpoint of the amicus curiae in this case. Let's have a look on that part. Supreme Court in Haribabu Tota has ruled that the corporate debtors promoter can submit a resolution plan under the insolvency. And here the fundamental point was between initiation date and the date when the resolution plan is proposed. Initiation date or CIRP commencement date, or the date of submission of the resolution plan. Let's have a look on that part. The Supreme Court in Haribabu Tota has ruled that the corporate debtors promoter can submit a resolution plan under the IBC if the corporate debtor obtains micro, small, medium enterprise MSME registration after being admitted into CIRP. So that is post commencement of CIRP, commencement date, but before the submission of the resolution plan. During that process, so once the application is admitted by the adjudicating authority, from that day up till the date when resolution plan is placed before, when the resolution plan is put before the resolution professional in response to their acceptance to my EOI. So Supreme Court emphasized that Section 29A of the Code aims to prevent those who are responsible for the corporate debtor's financial troubles from taking over the corporate debtor by submitting a resolution plan. But MSME are exempt from the provision due to the nature of their business. Supreme Court judgment has effectively overruled NCLAT judgment. We will be taking care of that side also. This Supreme Court judgment has overruled the judgment in Digambar Anand Rao Pingle versus Shrikant Madanlal Javar and others. We'll be taking care of that NCLAT order also. But this Supreme Court judgment has effectively overruled that NCLAT's previous judgment, Digambar Anand Rao Pingle versus Shrikant Madanlal Javar, which held that once CIRP is initiated, former promoter or director cannot tide over ineligibility under 29A of the code by giving MSME registration. In an appeal by the RP, here the RP has moved an appeal, apprehending far-reaching consequences on him after the resolution plan presented before the NCLT got rejected on the grounds that promoter could not present the plan. The division bench of Supreme Court, Sanjay Kishan Kaul and Sudhanshu Dhulia, set aside the impugned order, clarifying that a disqualification under 29A of the code against promoter applying for resolution plan is not applicable to MSME. Factual metrics. Sri Ashraya Infracon went into CIRP. Appellant in the instant matter got appointed as an RP for the said CIRP. So this appeal was preferred by Mr. Hari Babu, who was acting as an RP. And in the capacity of the RP, that application for MSME registration was made. The RP came up with a plan before the propounded by the promoter and approved by the COC. However, the application got dismissed on the grounds that promoter could not present the plan. The appellant, being RP in the instant matter, urged that such an order would having a far-reaching consequences for him, making him ineligible to continue as an RP, ineligible to be considered as a board, as a liquidator of the CD, and that his case must be referred to the IBBI for further actions for RP aired in putting up the plan that was not in consonance with the law. So with this apprehensions, the RP has moved before the Honorable Supreme Court. Court analysis. In absence of any representation from other side, so there was no other side, court has appointed amicus in the instant matter, not only for the matter affecting the appellant, but because certain issue requiring adjudication by us, more so in view of the impugned order relying on the earlier order of the NCLAT in Digambar Anandrao of Pingle. The court considered the following aspect: whether the resolution applicant was disqualified under the primary condition of 29A of the code, that was first; whether the corporate debtor not having MSME registration at the time of commencement of CIRP would disqualify such applicant under 29A, as benefit of 240A would not be available. So when the corporate debtor went into CIRP, that is an insolvency commencement date, on that day the CD was not having MSME status. But at the time when the resolution plan was proposed, the MSME registration was undertaken or was taken by the RP. The court has analyzed the clause of subclause C, clause G, and subclause H of 29A, which is not applicable to MSME. Pointed out that the section was added via Amendment 8 of 2018 with effect from 23rd November 17, with an object to cure the mischief of the person responsible for the financial situation of the company against trying to submit a plan and take over the company through backdoor. 29 AC provides for a lapse of 1 year from the date of classification as an NPA. But in this case, the court noted that in the instant fact, there were no bank dues to attract the concept of NPA, much less than 1 year period. Coming to 29 AG, court acknowledged that one preferential transaction was identified by the RP, but no order was passed by the adjudicating authority as on the date of impugned order. Section 29AH again had no factual application. So RP has identified the ineligibilities, but the promoter of the MSME were not falling within this ineligibilities. Court noted the submission that 3 clauses to section 29A were specific to promoter, and that the company's promoter was not disqualified or disentitled from presenting the plan. As pointed out by the court that the said issue was noted in the impugned judgment, but there was no finding in this behalf, since the said order was based on the issue of section 240A of the code. Court has given an opinion, considered whether enclate view in Digambar Anandara of Pingle set forth correct proposition of law. In said fact, the application for MSME certificate was made after the commencement of CIRP, and the opinion said that the unauthorized application could not be considered and could not tide over the inel. So the facts were different. In that case, the facts were different. It was the promoter, those who themselves have applied. In this case, the facts are different. The court therefore perused section 240A of the code, which was also introduced via Amendment 18. The court explained that clause C to clause H of 29A, which were applicable to promoter, exempting them from applying for a plan, was not applicable to any micro, small, medium enterprises, and the object was due to the nature of business carried on by these entities. The reference was also given to the Insolvency Law Committee in this regards. Court noted that under the heading exemption to MSME from 29A, the discussion begins. It has referred to the Insolvency Law Committee report of March 18, findings that MSME from the foundation of the economy are key drivers to the employment, production, economic growth, entrepreneurship, and financial inclusions. ILC report of 18 exempted these industries from 29A subclause C and H. The court observed that excluding such industries from disqualification under C and H of 29A is because quasi such industries other resolution applicant may not be forthcoming, which thus would inevitably lead not to resolution but to liquidation. So this kind of exemptions are only associated with the MSME. Court further noted that the challenge to 29A was repealed in Digambar Anandrao Pingle while extracting the statement of then finance minister while moving an amendment bill, giving the object of interpretation of 29A referring to the disqualification clause under 29AC was for those who were corporate debtor and provided the cutoff date as an application making a bid. So basically, it is not when CIRP was commenced, whether I was MSME registered or not, but the time when I am submitting my bid against the invitation for EOI. Conclusion, taking note of the submission that while interpreting 240A, the reason for carving out the exception in MSME is set out on the date of application for making the bid as a crucial date. While for some other aspect, in the IBC, while for other aspect, the initiation of CIRP proceeding would be the cutoff date. That is what we call insolvency commencement date. But the same will not apply in case of 240A in view of the statement by minister while introducing the amendment bill. So at the time when I place my resolution plan, rather when I bid against the invitation of EOI, when I bid, at that time I have to give a declaration or an affidavit with regards to my status as a eligible resolution applicant and not disqualified under 29A. This is very important. Taking note of the submission that while interpreting section 240A, the reason for carving out the exception in MSME is set out on the date of application for making the bid as a crucial date, while for some other aspect of the initiation of CIRP proceeding would be the cutoff date. So here what is going to be taken care of is as on the date of submission of the plan, or where as on the date when I'm bidding myself as a prospective resolution applicant. The court accepted the same in view of the notwithstanding clause, acknowledging that it was obvious that while seeking to protect this category of industry, the disqualification is not to be incurred. The court expressed that the date of initiation of CIRP proceeding, begin the relevant date was not correct legal view and observed that the law laid in Digambar Anandrao Pingle was not the correct one, and that the date of submission of the plan has to be the cutoff date. The court thereby explained that the plan submitted in the instant matter did not incur disqualification, and such intent was reflected in the statutory provision itself, 29 AC, which began at the time of submission of the plan. So when I submit my plan, so this was the view taken by the Supreme Court, the Honorable Supreme Court, in against the reason of the NCLED which was taken in the matter of Digambar Anandrao Pingle. In that case also, the MSME registration was availed after the insolvency commencement date. The only difference between that particular case and this very fact is, in that case, it was the promoter who deceitfully obtained that. Whereas in this particular case, it was the RP who has applied the same, as the promoter of the corporate debtor was willing to submit a resolution plan. I'm just sharing extract of the same, of that earlier resolution. Now, this is the NCLAT judgment in Digambar Anandrao Pingle case. Now, this is the NCLAT judgment. I would like to go to the operative part. Now, this is the operative part. The appeal has come up before us for hearing. The learned counsel for the appellant has not referred to any of the above ground raised by the appellant, which are referred in the appeal, and has limited his argument to request that the corporate debtor is now in liquidation, and in liquidation proceeding, the appellant has given a bid to take over the CD as a going concern. But the obstruction in the way of the appellant are the observation of the adjudicating authority in para 4 of the impugned order, holding that the appellant was hit by 29A. Learned counsel submitted that all the other ground raised by appellant in the appeal are not being pressed by the appellant, and the appeal is now limited to the observation made by the adjudicating authority in para 4. The learned counsel for the respondent number 1, appearing for ex interim resolution professional, submits that the appellant has in the appeal made various allegations which are incorrect, like making allegations that IRP connived with respondent number 5, the operational creditor, and other competitors. So in this particular case, if we just go with the facts, the appeal has been preferred by the ex-director and promoter of the corporate debtor, Messrs. Pingle Builders. The appeal has been filed against the impugned order passed by adjudicating authority, that is again NCLT Mumbai bench, which was filed by the RP, which were filed by the appellant in the matter of Mumbai NCLT bench, which was filed by the resolution professional, which were filed by the appellant in this case. Now, in this case, the appeal is basically against the passing of an order on the application of the resolution professional directing. So here the RP has moved an application for liquidation and not accepting the plan of the appellant, which has submitted submitted as a resolution applicant. So in this case, the resolution plan was set forth by the promoter, MSME promoter. The appellant claimed that the corporate debtor was an MSME and he could file a resolution plan. So that was an appeal preferred by the SBOD, Suspended Board of Directors. The appeal set out in various details so as how the CIRP was initiated, how earlier meeting resolved to go for a liquidation, but as how on request of the appellant, the COC reconsidered and recalled its earlier decision in meeting. The appeal shows that the appellant made efforts to settle under 12A of IBC with OC and with OTS for respondent number 3. Appeal shows that on 24th June 19, the COC again resolved that the company is required to go into liquidation. As per the appeal, the COC in its meeting held on 24th June discussed the proposal of the appellant and certain revisions were suggested. The resolution professional filed IA under 33 of the code for liquidation. The appeal claims that the appellant filed MA requesting withholding of the order of the liquidation and directions to COC to consider the settlement plan of the appellant. Appeal mentioned as how the adjudicating authority in its order directed RP to hold a meeting in 5 days so that COC could consider the revised proposal of the appellant. According to appeal, in 10th meeting of the COC, the appellant had offered a settlement which was accepted by respondent number 5 on the condition that the appellant would make payment of 30 lakh before 5th August. Appeal claims that the OC subsequently backed out of his proposal. Appeal claims that the appellant made further efforts for the settlement and also gave resolution plan, and the resolution professional has objected to the RP resolution plan in the meeting, and then the appellant tendered resolution plan before the adjudicating authority, and the adjudicating authority directed resolution professional to place it before COC. Appeal claims that in 12th meeting of the COC, the plan for the appellant was unanimously approved by COC subject to certain fulfillment, which were time bound as recorded in the minutes. The appeal highlights various efforts made by appellant for settlement. Appeal claims that it was filed to direct RP to hold COC meeting for final approval of the revised plan given by the appellant, which was given in compliance with the conditional approval of the resolution plan. Instead of this, the impugned order come to be passed, filed by the RP for initiation of liquidation proceeding, accepted, and the appellant to withhold liquidation was dismissed. Now, in this case, let's see. Basically, it was an MSME application which was made by the promoter themselves. Now, when this appeal has come up before the hearing, the learned counsel for the appellant has not referred to any of the above ground raised by the appellant, which are referred in the appeal, and has limited its argument to the request that the corporate debtor is now in liquidation, and in the liquidation proceedings, the appellant has given a bid to take over the CD as a going concern, but the obstruction in the way of appellant are the observation of the adjudicating authority in para 4, holding that appellant was hit by 29A. Counsel submitted that all other ground raised by the appellant in the appeal are not being passed by the appellant, and the appeal is now limited to the observation made by adjudicating authority. Learned counsel for the R1 appeared for ex-interim RP. Ex-interim resolution professional submits that the appellant has in the appeal made various allegations which are incorrect, like making allegations that IRP connived with our respondent 5 DOC and other competitors of the corporate debtor so as to ensure that the CD goes into liquidation. Learned counsel for the liquidator submitted that in the liquidation proceedings, the bids have been called in which the appellant has given a bid, and there are other bids also. The liquidator, in considering the eligibility of appellant in context with the observation in para 4, impugned order, and other relevant factor with regards to appellant. Now, here it is the crucial side. The learned counsel for the respondent number 5 is submitting that the corporate debtor was not an MSME. During the pendency of CIRP, the appellant procured the MSME certificate without authority. The appellant procured the MSME certificate without authority, copy of which has been filed in the appeal. The learned counsel for the respondent number 5 is also making various other allegations against the appellant to state that the appellant has acted fraudulently. Adjudicating authority in para 4, which was challenged. There are several allegations against the ex-promoter, who is also the resolution applicant herein, regarding the fraudulent transactions. Also, on earlier occasion, he promised to pay and later on failed to make the payment. Thus, this attempt by him appears merely to stall the proceedings and buy time. Also, the applicant in this 2MA is the ex-promoter of the corporate debtor against whom an application for preferential transaction was filed by RP. Hence, it is to be noted that the applicant get hit by 29A of the code and therefore restrained from filing resolution plan. Adjudicating authority reproduced 29A. In para 5, adjudicating authority had made observation. The learned counsel for the appellant is submitting that if clause G of 29A of the IBC is seen, the party get debarred if an order has been made by the adjudicating authority in that regard. It is stated that MA filed under 43, 66 and 65 is still pending before the adjudicating authority, and order in this regard has not been passed. Thus, according to learned counsel, the appellant should be permitted to participate in liquidation to bid for taking over the CD as a going concern. Learned counsel for the liquidator accept that MA is still pending. Having gone through the matter, although the appellant having backed upon his efforts made to settle with the OC and also with other creditors so as to bring the withdrawal of 12A, and relied heavily on his efforts to show that the appellant was trying to bring through a plan filed by him and his resolution plan was required to be accepted, the fact remains that the record does not show that the resolution plan as such of the appellant was approved by the COC at any given majority. Section 9 application was admitted on 19 July and liquidation order was passed by adjudicating on 11 December. This is more than 2 years of the time. Clearly, if in the time prescribed under Section 12 of the IBC, resolution was not reached in given time, liquidation is the only consequences which has to follow and which has been ordered through belatedly. Here in this case, coming to para 4 of the impugned order, the argument of the learned counsel of the appellant is attractive that there must be an order required under clause G. A person shall not be eligible to submit a plan if such person or any other person acting jointly or in concert with such person has been a promoter in the management. So there has to be a kind of, you can say it is provided that there has to be an order required under 29 AG. This is yet another factor which is relevant, and we find that the appellant has obtained MSME certificate for which the application has been made on March. The CIRP with regards to the corporate debtor started on 19 July and 5th March. The corporate debtor was under management of IRP. Appellant had not shown that the application for MSME was made. Now, this is the big difference. In the matter of Haribabu Thotha, it was he who moved an application because he was in the helm of the affairs during CIRP. But in this case, the observation is appellant has not shown that the application for MSME was made through IRP or RP. Learned counsel for the respondent number 5 is claiming that there was no consent of IRP and RP. When the corporate debtor was not under the management of the appellant, such unauthorized application could not have been made, and the claim of the appellant that the CD is MSME would require to be ignored. The appellant cannot take the advantage of his own wrongful act, keeping in view the judgment in the matter of Arun Kumar Jagatkarma and Jindal Steel. Backdoor entries cannot be allowed. After CIRP was initiated, the former promoter and director cannot suppress from IRP or RP an application for MSME certificate and tied over ineligibility under 29A. So this is the basic difference between what was there in this particular order and what has been decided by the Honorable Supreme Court in the matter of Haribabu Thotha. So this was the judgment of Anclet in the matter of Digambar Anand Rao Pingle versus Shrikant Madanlal Javer. Now, just I would like to take up the views of the participant with regards to 10A, because I have seen in this case, 10A is something which is quite ambiguous in nature. So there is a suspended period which is decided by the 10A, that is 25th March 2020 till 24th March 2021. So in case if default is falling within this time frame of suspended period or a prohibited period, no such application can ever be filed. But in this case, I just wanted to have your views in this case. Now, in one of my case, the invoice pertains to 10A period. This is just a case which I'm sharing with you. The invoices are relating to the COVID period or suspended period or a prohibition period. That is 25th March 2020 to 24th March 2021. So all the invoices are pertaining to 10A period. There was a stipulation in the invoices that the payment has to be made within 60 days. Furthermore, there is no case of default during 10A period. So it was not a mutual, it was a non-mutual running account. So invoices were not being settled against the invoices, or the amount was not being settled against the invoices, but it was non-mutual running account. There was no default during 10A period. In fact, I have received a regular payment during 10A period. But the default has started. CD has stopped making payment from June 2021 onwards. CD has stopped making payment from June 2021 onwards. So basically the date of default, if I does not go with a date of default pertaining to my first unpaid invoice, then in that case, in my case, the date of default is a date when I have stopped receiving payment from the corporate debtor, and that is June 2021. So that was the date which I have mentioned in my application in form number 5. I have mentioned the date as the last date on which I have received the payment from the CD, that is June 2021. In that case, the views taken by the adjudicating authority is that should not be, the date should not be a last date of default, or last date of payment should not be considered as a date of default. And for every invoice, there will be a separate date of default. Now, here the point is, when invoices were not being settled on account basis, I said invoices were not being settled on invoice basis, or it was a non-mutual running account. And as such, there was no default which has ever taken place during that prohibition or during that suspension period. But I have stopped receiving payment from June 2021 onwards. Then how come the provision of this 10A will be applicable? That is one point. Second, if see, the purpose of 10A is to immune a corporate debtor during that hardship period, that if the default is pertaining to that 10A period, no application for CIRP can ever be initiated. But I said that does not give them a flexibility of keeping the default continuous. Now, suppose if my all the invoices are pertaining to 10A period, there was no payment which I have received against those invoices during that suspension period. But after the completion of 24th March 2021, the corporate debtor has started making certain payments. So this is settled that all the invoices, if I go with the terms of the invoices, then default will be the due date when the payment was supposed to be made. But when I have started receiving payment on completion of the suspension period, the corporate debtor has made an attempt to make the payments in the year 2021. In the year 2022, the corporate debtor has again failed to make the payment. In that case, again, I will not refer the 10A period as a date of default, and I will refer the date when I received the last payment as a date of default, even though my unpaid invoices are pertaining to 25th March 20 to 24th March 21. Now, I just wanted to have your views in this connection, because 10A, the ambiguity still survives. I'll appreciate in case if you can share your views on the same. Then I think that the ambiguity only lies with me only, or the lack of clarity is only with regards to this particular provision of 10A is only akin to me. Yes.
Sir, for that, I need to go first for section 10A, sir. It
Please,
will
sir.
be better if you good sir, please share that section, sir.
Allow me some time. I'm sharing provision of
Please,
10A.
please, sir, please, sir. May I share, sir?
Is this visible?
Yeah, please, sir.
This is 10A.
Yes, sir. Sir, first of all, if we go through section 10A, that is suspension of initiation of CIRP, notwithstanding anything contained in sections 7, 9, and 10, no application for initiation of CIRP of a corporate debtor shall be filed for any default arising on or after 25th March 2020 for a period of 6 months or such further period not exceeding 1 year from such date as may be notified in this behalf. Provided that no application shall ever be filed for initiation of CIRP of a corporate debtor for the said default occurring during the said period.
So basically, there are 2 points which we can note down. Default arising on or after 25th March for a period of 6 months extended to 1 year. That
Yes.
is the first proviso.
Hmm.
Second proviso says default occurring during said period. Now, my point is that only that default arising on or after for a period of 1 year and default which is occurring during said period. So, in that case, in my first case, there was no default occurring during said period. There was no default. I have got time to time payments from the corporate debtor during entire 10A period. From 25th March 2020 onwards up to 24th March 2021, the corporate debtor was consistent in making payment even thereafter till June 2021. And it was the last payment which I have received in the month of June 2021. That is point one. Another point is, anyways, let's discuss first point. And here I would like to have the viewpoints of your learned members.
So regarding this first point, because from 25th March 2020 to 24th March 2021, because during this period, if transactions fall due, sir, and after that period, as per your view, sir, you have received the payment. It means that period, that the payment received by you after the that after expiry of that period, that it means that is giving extensions of the limitations period. What I understand, sir.
Limitation is not a concern. It's not a subject matter here.
But sir,
limitation is not a question. Limitation was not an issue. My application was well within limitation period. My only limited concern before the adjudicating authority was that there was no default which has occurred during that period, which is the first proviso all about. If the default has occurring during said period. So basically the privilege to this 10A is only given for that period during which the COVID has impacted and hardship was faced by such corporate debtor.
yes.
So in case if the default has occurred during said period, such a privilege can be extended to them. But in my case, when the payment was received from time to time, in no case they have committed any point of default. Now the only concern is, in case of operational creditor in 90 out of 100%, majority of the payments we used to receive on account basis rather than they settle the same on invoice basis. So I was regular in getting the payment, but thereafter on completion of the COVID, June 2021 was the last month on which I have got the payment. So basically in my understanding, the default has occurred not during 10A period, but default has occurred after completion of 10A period.
But sir, if the due date falls within that period, definitely the default will be during that period, sir.
So in that circumstances, what you mean to say is the invoices, each invoices I have to calculate my separate date of default.
That is there, sir, but that is there. Ultimately, here, if you again go through the provisions of this, as per my understanding, I again study, sir, notwithstanding anything contained in section 7, 9, 10, no application for initiation of CIRP of a corporate debtor shall be filed. Here, this line, sir, and the second para, first line, provided that no application shall ever be filed. That will give continuity of the default, sir. If that will be that I think so that is not the intent of the court, sir. Then in that case, most of the cases will fall under this category, sir.
Absolutely. So basically what my point is, suppose if during 10A period, if I have purchased certain goods and I know that 10A will allow me and will keep me immune, if I does not make any payment during the 10A period and all the invoices which are pertaining to 10A period, at least I will be liable to make the payments for the invoices pertaining to outside 10A period. So when I will start making the payment for those invoices which are outside the purview of 10A period, in that case, the amount will be adjusted against those invoices which pertains to 10A period or invoices which are outside the purview of 10A period. So basically 10A is something which is being misused.
Okay, sir.
One more section which I feel wherein some clarity is required, and that is section.
Sir, in this second, is it okay what I have said, sir, or is there some you have some other
It's
opinion?
all about, sir. It's your point of interpretation which was taken in my case as a stand by the NCLT. But still, I am not so convinced as far as the stand which the Honorable Tribunal has taken. And the another one which I feel that it requires a discussion is section 30, subsection 5.
Okay, sir. Please, sir.
This is the resolution applicant may attend the meeting of the committee of creditor in which the resolution plan of the applicant is considered. Now, what happened and what is happening? In what is happening that a person who is a member of the COC,
Yes, sir.
a person who is a member of the COC will always get a benefit and will always having some extra age over the resolution applicant who is not a member of the COC. Now, suppose if I'm the member of the COC having 30% voting rights,
Okay,
and
sir.
I'm also one of the resolution applicant, in comparison to one another resolution applicant who is not a member, a non-member of the COC. So if I, being a member of the COC, placing a resolution plan before the COC, and a non-member of the COC placing a resolution plan before the COC, they all are not ranking parallelly. And the one who is a member of the COC is getting an extra age over the other resolution applicant, meaning thereby when the COC consider or approve any resolution plan, in my viewpoint, this subsection 5 of section 30 creates a greater benefit to the one who is a member of the COC because he is having an opportunity to pass or to cast vote even on his own plan, which should not be allowed. One cannot sit over the commercial wisdom over its own plan. In the Companies Act, there is a provision interested directors are not allowed to vote or participate.
I agree, sir. Definitely.
But no such kind of provision is there in the IBC. When you read subsection 5, it states that applicant may attend the meeting of the COC in which the resolution plan of the applicant is concerned. Allowed to attend the meeting, but here the word attend is also extended that they are also permitted to vote. Now, suppose if I am one of the resolution applicant and a member of the COC holding 30% voting share, if I will sit over the reason of commercial wisdom over of my own plan, I will always carry a prejudiced mind. And in comparison to the one who is submitting a resolution plan and who is non-member, my vote will always cast against that plan because my own plan is before consideration.
Yes, sir.
So I think again, this is one of the section which requires some clarity from the board or from the ministry, because in that case, if I am the member of the COC and also a resolution applicant, I will be, or my voting shares in case are enough for approval or for the rejection of any resolution plan, then I will be having a benefit over and above the other resolution applicant who are a non-member of the COC. In case if my voting shares are enough to either approve or to roadblock other resolution plans.
Yes, sir.
Just because of subsection 5 of section 30. I appreciate the views of other members of the present program or present webinar. I'll be moving to the another case laws then.
Thank you. I बोला चाहते ठीक बोल रहा है आपने।
Now, this is one of the case law. Again, wherein the anklet has made the things more clear. Now, this is the case when judgment passed in the matter of Ashmeet Singh Bhatia versus Pragati Impacts India Private Limited. It is again the anklet judgment in the matter of Ashmeet Singh Bhatia, which is the appellant here, and he is challenging the order which is passed by the NCLT rejecting his application. Now, this is something wherein the core subject or the moot point of the appeal was the appellant, Mr. Ashmeet Singh Bhatia, has challenged the application which was made against the corporate debtor by the financial creditor. So it is the case wherein the financial creditor has moved an application under section 7 against the corporate debtor. That application was admitted. And the appellant here in this case, Ashmeet Bhatia, his locus was challenged. Post admission, Mr. Ashmeet Singh Bhatia has moved an application before the NCLT, but NCLT has rejected that application. This application was made by Mr. Ashmeet Singh Bhatia under section 65, mentioning some collision or some connivance between the financial creditor and the corporate debtor. So it was a claim of Mr. Ashmeet Singh Bhatia that application was made with a malified intention to drag the corporate debtor into insolvency in a structured manner. In the matter of Ashmeet Singh Bhatia versus Pragati Impacts India Private Limited and others, the NCLT, the National Company Law Appellate Tribunal, this is reported in this. It's filed by Ashmeet Singh Bhatia challenging the order dated 1st September 23, passed by NCLT rejecting application having case number this. The reason for rejecting the aforesaid application by Honorable NCLT having case number IA 4654 is mentioned as follows. So why it was rejected? The admission order of initiation of CIRP against the Pragati Impacts was affirmed by Honorable Anklet. The appellant in this appeal filed in Honorable Anklet claiming to be a home buyer. So the appellant has claimed himself as a home buyer in a sister concern company of the corporate debtor and has made a serious allegation of collusion and fraud against the financial creditor and the corporate debtor. So basically, Ashmeet Singh has moved an application before the NCLT challenging the application which was made by the financial creditor against the corporate debtor. And his locus was he was one of the home buyer in a sister company of the corporate debtor, which was also in CIRP. The appellant in its application has stated that the alleged debt was transferred in a circular manner. So there was a round tripping of fund. The appellant in its application has stated that the alleged debt was transferred in a circular manner back to one of the group company of the financial creditor on same day. In the application filed by the appellant has brought on record that on June 2, 2018, Messrs. Oasis Suppliers Private Limited transferred an amount of 1 crore 75 lakh to financial creditor. OSS supplier transferred an amount of 175 to financial creditor. Financial creditor transferred the same amount to CD, and CD transferred the said amount back to OSS Suppliers Private Limited. This is the diagrammatic show wherein amount which is being transferred from Vistar Constructions Private Limited corporate debtor. This amount is coming from OSS Suppliers Private Limited, and OSS Suppliers Private Limited are getting money. Pragati Impacts India Private Limited, that is a financial creditor, and against the amount which corporate debtor has received from OSS is being transferred back to Pragati. So basically, the financial creditor has got the money back, but he moved an application of Section 7. Honorable Enclate observed the prayer mentioned by the appellant in the application made section 65 and further to conduct the inquiry regarding collusion. Honorable NCLT provided that if the NCLT came to the conclusion that the insolvency proceedings have been initiated fraudulently or with malicious intent for any other purpose other than resolution of the insolvency of CD, then adjudicating authority can impose a penalty as provided under 65 of the code. Even after admission of CIRP order by NCLET, the jurisdiction of, now this is very important, even after the admission of CIRP by the NCLT, admission of CIRP order by NCLT, the jurisdiction of adjudicating authority, that is NCLT in this case, to examine the allegation of 65 does not denude. So NCLT cannot say that this application has been admitted and hence section 65 application should not be allowed, or locus in this case was also challenged. To examine the allegation made in 65 does not denude. The relevant paragraph of this judgment is reiterated below. The power under 65 of the code can be exercised by the adjudicating authority only after satisfying that ground as mentioned exists. If the adjudicating authority come to the conclusion that insolvency proceedings have been initiated fraudulently or with malicious intent for any other purpose other than that of the resolution of the insolvency of the CD, it can impose penalty as provided in that provision. While exercising jurisdiction under section 65, the adjudicating authority is fully entitled to close CIRP process and pass all consequential order. The mere fact that section 7 application has been admitted does not denude the jurisdiction of AA to examine the application under 65. This is very well provided. While exercising jurisdiction under 65, NCLT is fully entitled to close CIRP and pass all consequential order. The mere fact that section 7 application has been admitted does not denude the jurisdiction of adjudicating authority to examine section 65 application. The observation of adjudicating authority are that the appellant is opposing the admission of proceeding which admission has been affirmed by appellate tribunal. The above does not denude the jurisdiction of adjudicating authority to examine the allegation of 65 even after admission of the proceedings under 7. The Honorable NCLT observed that appellant had the locus to file the application in Honorable NCLT as the appellant being adversely affected due to commencement of CIRP against the CD because the appellant is the home buyer in a group housing project of Granite Gate Properties Private Limited, and Granite Gate Properties Private Limited is undergoing CIRP and is actually a sister concern of the CD, which has to receive an amount from the corporate debtor. So this was the locus. The locus is defined that appellant had the locus to file an application before the NCLT, which is being adversely affected due to commencement of the CIRP of the CD, because the appellant is the home buyer in a group housing project of Granite Gate Properties Private Limited, and that Granite Gate Properties Private Limited is itself under CIRP, is a sister concern of the CD, and which has to receive an amount from the CD. Additionally, Honorable NCLT, while replying to the respondent connection, stated that the mere fact that the application by appellant has been filed at the time when the resolution plan for the CD is under consideration does not take away the jurisdiction of NCLT to consider the allegation and find out the truth, if any. It is therefore the Honorable NCLT wide judgment dated Feb 2nd, 2024 held that the adjudicating authority committed error in rejecting the application without considering the application on merit. In result, the order dated 1st September 23 set aside application is revived before the adjudicating authority to be considered and decided in accordance with the law. We further observe that the adjudicating authority shall proceed to consider the application for approval of the plan after deciding this IA. So this is one of the case wherein Section 65 application was made by the appellant before the NCLT. NCLT has rejected, citing the locus, citing the fact that already the resolution plan of the corporate debtor is under consideration. So considering this aspect, the application was rejected. Appellant has moved, so that appellant has moved before the NCLT, and NCLT has pointed out that even though even though the corporate debtor is in CIRP, even though the resolution plan is pending for consideration, but NCLT, being an adjudicating authority, is empowered to take care of Section 65 application. And if that 65 application is based on certain ground which gets proved, NCLT do have power to stop the CIRP proceedings and initiate an action for the violation of section said provision of the law, considering the provision of section 65 of the code. So this is one of the judgment which is of the NCLT.
Sir, I have one query here, please.
Yes, sir.
Sir, one guidance I need. Is Section 65 application can be filed after approval of resolution plan, sir?
Why not? Now, this is what the NCLAT has mentioned.
Okay, sir. Thank you, sir. Thank
Because consequences will follow.
Okay, sir. Thank you, sir.
Now, this is going to be a recent judgment of the Bombay High Court. And this is just in order to clean the air of PMLA versus IBC. I'm just sharing. This is in the matter of Shiv Charan and others versus adjudicating authority and another, and Directorate of Enforcement versus Shiv Charan and another. So there was a cross writ petitions which were filed. Is this visible?
Yes, sir, please, sir.
Now, this is the question pertaining to whether NCLT has jurisdiction to direct ED to release the attached properties invoking 32A of the code once the plan that qualifies for immunity under 32A was approved. Now, the provision is very clear as far as section 32 of the Insolvency and Bankruptcy Code is concerned. So the question before the Honorable High Court, Bombay High Court, was whether the NCLT is having a jurisdiction to direct ED to release the attached properties invoking section 32 of the code once the plan that qualifies for immunity under 32A was approved. So Bombay High Court has entertained this writ jurisdiction, the writ petition. The division bench of the Honorable High Court of Bombay recently rendered a significant judgment in relation to the jurisdiction of NCLT under 32A of the code to direct ED to release the property of the CD attached under PMLA once resolution plan in respect of the corporate debtor is approved. The tussle of whether the IBC overrides PMLA has always been a continuous issue before the various fora across the country, even after the introduction of 32A of the code with effect from December 28, 2019. Section 32A of the code states that liability of the CD for any offense committed prior to the commencement of CIRP shall come to an end, and the CD shall not be prosecuted for such offenses from the date on which the plan has been approved by the Honorable NCLT. 32A of the IBC also accords protection against any action on the property of the CD in respect of any offense committed prior to the commencement of CIRP. And this is the crux of 32A, which states that it accords protection against any action on the property of the CD. Any action on the property of the CD in respect of any offense which was committed prior to the commencement of CIR. The facts are, the dispute in the present case emanates from two orders. One is order dated 17th April 23, approving a resolution plan for DSK Southern Projects Private Limited CD, submitted by Shivcharan, Pushpalata Bai, and Bharti Agrawal, collectively referred to as the SRAs. Order dated 28th April, 10 days later, directed the ED to release the attached property of the CD, which were attached before the commencement of CIRP 2023 order. So here the facts are, the dispute in the present case emanates from two orders. One is approval of the resolution plan. Approving the resolution plan for the corporate debtor, that is a DSK Southern Projects Private Limited, submitted by Shivcharan, Pushpalata Bai, and Bharti Agrawal, which are the collectively considered as a successful resolution applicants. An order passed by the NCLT directing ED to release the attached property of the CD, which was attached prior to the commencement of CIR. In pursuance to the aforesaid order, two writ petitions were filed. Writ petition filed by the successful resolution applicant, that is Mr. Shivcharan, Pushpalata Bai, and Bharti Agrawal, quashing the enforcement case information report and order attaching the property of the CD. And second was filed by the ED challenging the authority of the NCLT to pass the order in connection with the action taken by ED under PMLA, invoking 32A of the IBC for quashing of the April 23 order. So one writ petition was filed by the successful resolution applicant for quashing the enforcement case information report and the order attaching the property of the CD is concerned. And another writ petition was filed by the ED itself, which has challenged the authority of the NCLT to pass an order in connection with the action taken by ED under PMLA by invoking 32A of the code for quashing of 2023 order. Analysis. The arguments which were advanced by the ED counsels were, the ED contended that the corporate debtors' property were attached prior to the commencement of CIRP, and NCLT does not have jurisdiction to traverse beyond the ambit of IBC and decide upon the issue pertaining to PMLA in the process of approval of the plan. Whereas successful resolution applicant has alternative efficacious remedy under PMLA, including right to move an appeal under 26(1) of PMLA against the attachment and right under 8(8) of PMLA for restoration of confiscated property. So that was the contention which was made by, or which was raised by, the counsel of the ED. The first contention raised by the counsel of the ED was that NCLT do not have any jurisdiction to traverse beyond IBC and to decide upon the issue pertaining to PMLA in the process of approval of the plan. And the second one is the remedy which is available with the SRA under PMLA. That is right to appeal under 26(1) of PMLA and also right under section 8 subsection 8 of PMLA for restoration of the confiscated properties. Now what the SRA has given in submission or in contra, what views which has been placed by the SRA. In opposition, the SRA argued that 32A of the IBC is non-obstant provision, which overrides PMLA in case of conflict. The attachment under PMLA is an interim measure, which becomes final on confiscation under 8(5) of PMLA. And since 32A of the code provides protection against the confiscation of the property, the attachment should be released. Pertinently, 32A is a special automatic framework which get triggered upon the approval of the plan. Hence, SRA is required to approach the authority or court under not required to approach the authorities or court under PMLA. What the court has finding, or Bombay High Court has their own findings in that case. The main issue before the court was whether NCLT had jurisdiction to give directions to ED for release of the CD's attached property, invoking 32A of the code. After considering the argument advanced and the precedent cited by both the parties, that is by ED and by SRA, through writ petition, the court inter alia held that NCLT was well within its jurisdiction in declaring the CD would stand discharged from the offences. Just take care of it. NCLT was well within its jurisdiction in declaring the corporate debtor would stand discharged from offences alleged to have been committed prior to CIRP, and that the attached property of the corporate debtor shall become free from attachment upon approval of the plan. The court has also observed that 32A of the code is non-obstant provision, enabling an automatic discharge from prosecution. Immunity is available, a very important. Immunity is available solely to the corporate debtor, and only when the plan is approved by governing a complete change in the control and management of the CD. So, meaning thereby, this immunity under 32 will not be extended if the resolution plan pertains to their own promoters. This is provided that such immunity is available solely to the corporate debtor and only when the plan is approved governing a complete change in the control and management of the CD. So this is one of the vital things to take care of. IBC is a non-obstant provision enabling automatic discharge of the property from the prosecution, but immunity is available to the CD only when if the plan is approved governing a complete change in the control and management of the CD. Otherwise not. The aforesaid protection is also extended to the property of the CD under 32A subsection 2. The court also examined the purpose and the object of 31 and 60 subsection 5 of the IBC, which explicitly deposits that the legislature has enjoined NCLT with the duty to ensure that the plan can be effectively implemented and with the jurisdiction to dispose of any question of law arising in relation to resolution proceedings. Rule 11. Court relied on the landmark judgment of Manish Kumar versus Union of India, upholding the constitutional validity of 32A to the feature the legislative intent behind 32A, which provision give immunity to CD from action taken by the authority, including authorities under PMLA. Hence, once the condition under 32A of the code are met, any further prosecution against the corporate debtor and its properties shall cease, and the CD is the only required to cooperate, assist the authorities in continued prosecution against the individuals involved in the offense. But this is one of the very important nature of the judgment which is recently passed in this particular case. These are very vital. SRS argued that under 32 of the IBC is a non-obstant provision which overrides PMLA in case of conflict. The attachment under PMLA is an interim measure which became final on confiscation under 8.5 of PMLA. 32A provides for protection against the confiscation of the property. The attachment should be released. Pertinently, 32A is a special automatic framework which get triggered upon the approval of the plan. But this is subject to the condition when plan is approved, governing a complete change in the control and management of the CD. And the findings which has been tendered by the Honorable High Court of Bombay is that once the condition under 32A of the code are met, any further prosecution against the CD and its properties shall cease, and the CD is only required to cooperate or assist the authorities in continued prosecution against the individual involved in the offense. So this immunity will only be extended if the CD is being taken care of by a complete different management. If the resolution plan is approved governing a complete change in the control and management of the CD. So this is the case which was arising out of Mr. Shiv Charan and others versus adjudicating authority and others. So this is one of the important and a very recent judgment of the Bombay High Court. Anything for furtherance of discussion in this connection? One more judgment, which is again of the NCLAT, which clearly states that the adjudicating authority cannot direct COC to consider the suspended management settlement proposal without giving opportunity to successful resolution applicant. So suppose if the resolution plan tendered by a successful resolution applicant or a resolution applicant is approved by the adjudicating authority, approved by the COC, in between, if the suspended management place a settlement proposal, then in that case, the COC cannot be directed by adjudicating authority to consider the settlement proposal vis-a-vis the resolution plan if the resolution plan is already approved. I'm just sharing a screen with regards to appellate tribunal has passed an order in the matter of One City Infrastructure Private Limited versus Pratham Expo Fab Private Limited. This is again a very recent order of the NCLAT, which was passed on Feb 28, 2024. So this is something wherein this appeal was filed by the successful resolution applicant. I said this appeal was filed by this One City Infrastructure Private Limited, which is the appellant in this case, a successful resolution applicant, against the order dated 23rd Jan 2024 passed by NCLT New Delhi bench. So NCLT New Delhi bench has passed an order on 23rd Jan 2024, which has been preferred before the NCLAT by successful resolution applicant. Because in this case, the plan of the successful, the resolution plan of the SRA was approved by the committee of creditor. And thereafter, the corporate debtor, the suspended management, they have placed an application that is IA 188 of 2024, which was filed by the respondent number 1 for approval of their settlement proposal, consideration of their 12A application. The brief fact of the case which are necessary to be noticed for deciding the appeal are: point 1, CIRP of the corporate debtor, that is Primrose Infratech Private Limited, commenced by an order dated 21st December 18. Public announcement was made on 3rd Jan 19. CA 315 of 19 filed by ex-director seeking withdrawal of the CIRP. Just take care of it. This was an IA filed by the ex-director seeking withdrawal of the CIRP, but it was rejected by the adjudicating authority in the month of April 19, which order was challenged in the company appeal. The second application, being IA 1511 of 19, was filed by ex-director under 12A, which was directed to be placed before the committee of creditor. On 13 Feb 2020, the resolution plan submitted by the appellant here is the successful resolution applicant. On 13 Feb 2020, the resolution plan submitted by the appellant was approved by the COC with 80.84% voting share. IA 1489 of 2020 was filed by the RP for approval of the resolution plan, but which is pending before the adjudicating authority. In the meeting held on 19th Feb 2020, the proposal of ex-director for withdrawal of the CIRP was considered and rejected by the COC. So not once, but twice. In IA 188 of 2024, that was again filed by the suspended management, was filed by respondent number 1, ex-director, before the adjudicating authority with following relief. One is allow instant application filed by the applicants, pass an appropriate order to allow applicants to place settlement proposal under 12A, which was already rejected, read with regulation 30A before the committee of creditor for voting, and allow consequent withdrawal and suspension of CIRP admitted under 9. But by that time, already the application of this was filed by the suspended management. IA 188 of 24. But much before that, the resolution was approved on 13th Feb 2020, but it was pending for approval before the adjudicating authority. On application IA 188 of 24, the adjudicating, now this order was challenged. This order passed in the matter of IA 188 of 24 was challenged before the NCLAT. The adjudicating authority passed an order, which is an impugned order, directing applicant to deposit 1 crore in CIRP account of the CD, and RP was directed to call a meeting of COC to examine the proposal made by the applicant vis-a-vis proposal made by SRA. Agreed by that order, which is passed in IA 188 of 24, the SRA has moved an appeal. So this is the case. The resolution plan of SRA was approved long back in the year 2020 itself. In the year 2020, that is the Feb 2020, in the beginning of 20, the plan submitted by appellant was approved by the COC with 80.84% voting share. Thereafter, IA filed in the year 2020 was filed by the RP for approval of the plan. So meaning thereby 1489 of 20 is pending before the consideration of the adjudicating authority. But in the meeting held on 19th Feb, the proposal of ex-director for withdrawal of the CIRP was considered and rejected by the COC. So this is the fact. 13 फरवरी 2020, when successful resolution applicant का जो plan है that was approved by the COC, उसके basis पे RP has moved an application, interim application, again interlocutory application for the approval of plan by the adjudicating authority. और 13 फरवरी को COC has approved the resolution plan. उसके एक week के अंदर the ex-director has moved an application for withdrawal of the CIRP, but which was considered and rejected by the COC. Meaning thereby the successful resolution applicant's plan was already approved by the COC, but pending for approval of the adjudicating authority meantime. And I don't know how and why the adjudicating authority has entertained the promoter, the ex-director again and again on the same grounds. IA 188 of 24 dated January 24 was filed by the R1 ex-director before the adjudicating authority for following prayers, and the prayer was one against the same. Pass an appropriate order to allow applicants to place settlement proposal under 12A, read with regulation 30A before the committee of creditor for voting, and allow consequent withdrawal and suspension of the CIRP. On application, and this is something which is a great height, wherein the adjudicating authority, with IA 188 of 24, has passed an order directing applicant to deposit 1 crore in CIRP account of the CD, and RP was directed to call meeting of COC to examine the proposal made by applicant vis-a-vis the proposal made by SRA, against which the SRA got aggrieved and preferred this appeal. Senior counsel appearing for the appellant, challenging the order, submits that after the approval of the plan of the appellant by COC, there was no occasion for directing the consideration of fresh settlement proposal submitted by ex-director to be placed before the COC, where the earlier applications filed by ex-director under 12A were already considered and rejected twice by COC. It is submitted that after the approval of the plan, there is no jurisdiction in the adjudicating authority to direct for consideration of any application under 12A. That was the call, or that was the say, or that was the contention of the SRA, that when my plan was approved in the year 2020 by COC with 80% voting share, and twice the ex-director settlement proposal was rejected by the COC, then why such further application is being entertained? The learned counsel for the appellant submits that the adjudicating authority in the impugned order has relied on the judgment of this tribunal. The adjudicating authority failed to notice that the direction issued by the adjudicating authority for arriving at an acceptable settlement by next date was set aside by this tribunal. The adjudicating authority, although noticed the judgment, but has failed to notice the ultimate direction passed by the appellate tribunal. Learned senior counsel for the appellant has relied upon certain judgments. We are not going into that. Learned senior counsel for the appellant further submits that the adjudicating authority has passed an order in IA 188 on first date of hearing without giving any opportunity. So it is obvious that the successful resolution applicant is bound to feel aggrieved in such a case, wherein such application which is moved by the ex-director for proposing a resolution plan before COC without giving any opportunity to successful resolution applicant or the resolution applicant whose plan was approved by the COC, the order is passed in IA 188 of 24. In the appeal, the learned counsel for the appellant has taken a specific ground that no opportunity was granted, no opportunity was given to the appellant to respond to the application, and on the first date of hearing, an order was passed on the application, which is in violation of the principle of natural justice. Learned senior counsel appearing for RP supported the submission of learned senior counsel for the appellant submits that the resolution plan of the appellant having been approved by the COC, no directions could have been issued to place the application filed by ex-director IA 188 of 24 for consideration before the COC. It is submitted that the adjudicating authority itself has made observation that plan approval application was impeded at every stage by ex-director. In spite of the above observation, the adjudicating authority has directed the application to be placed before the COC. So no opportunity was given to the resolution applicant whose plan was approved by the COC. It is submitted that there was no jurisdiction for placing any proposal under 12A after the approval of the plan. The counsel for the RP has also relied upon certain more judgments. Learned senior counsel appearing for respondent opposing the submission of the counsel of the appellant submits that the adjudicating authority is not precluded from directing consideration of 12A submitted by ex-director, since the application for withdrawal of the proceedings can be allowed at any stage. The mere fact that plan of the appellant has been approved by COC does not preclude the consideration of 12A proposal submitted by the appellant. But one thing which is something out of my understanding is why the ex-directors was given too much opportunity in spite of his proposal was rejected twice by the COC. It is submitted that the adjudicating authority has directed for consideration of the application with certain condition, including deposit of 1 crore by the applicant. The learned counsel for the respondent 1 and 2 has relied on the judgment of Honorable Supreme Court, Brilliant Alloys Private Limited and S. Raj Gopal and others, wherein the Honorable Supreme Court has taken the view that there are no restriction in 12A and stipulation under 30A has to be construed as directly depending on the fact of each case. The learned counsel for the respondent has also relied on certain more judgment where this tribunal has observed that in an application filed under 12A, COC may decide whether the proposal given by appellant for settlement is better than the resolution plan as approved by the COC. In its submission that as per the above judgment, COC can very well consider the proposal. So the litigation, the point or the dispute was one only. One is, if my plan was approved by the COC and it is pending for the approval of the adjudicating authority, then why the ex-director is allowed again and again, in spite of the earlier rejection, to place the resolution, to place the settlement plan? And moreover, why his application is being admitted for the same reason for which he moved an application in the past but got rejected? And another moot point of the appeal was why the order was passed in IA 188 of 24 without giving an opportunity in that connection to the resolution applicant whose plan was approved by the COC. From the facts which have been brought on record, it is clear that the earlier applications filed under 12A by ex-director was considered and not approved by the COC. On Feb 20, the plan of appellant was approved by the COC, but it was pending for the approval by the adjudicating authority. We have looked into IA 188 of 24, which was filed by the respondent 1 and 2, where the applicant have referred to the proceedings subsequent to the filing of the application for approval of plan. filing of IA 5403 seeking certain clarification of the order passed by adjudicating authority has also been referred to. Reference to the affidavit filed by SRA clarifying the issue has also been noticed in paragraph 6. The appellant has submitted a proposal in paragraph 9 of the application. The application which was filed by the respondent number 1 and 2 came for first time before the adjudicating authority on 23rd Jan, which date order passed by the adjudicating authority direct applicant to deposit 1 crore and subject to deposit, the RP was directed to call COC meeting to examine the proposal vis-a-vis the resolution plan. The adjudicating authority in the impugned order has relied on certain judgments in which the tribunal has set aside the part of direction issued by the adjudicating authority giving opportunity to ex-director. The direction with regards to opportunity granted to ex-director so that any settlement can be arrived was set aside. However, the tribunal directed application for approval of the resolution plan should be considered and decided, as it was also open for the adjudicating authority to consider 2594 of 23 filed by R1 in the operating portion of the order following was observed in last paragraph. In view of the aforesaid discussion and our conclusions, we are of the view that adjudicating authority committed error in giving an opportunity to R1 to arrive at acceptable settlement. Thus, following the observation in the order are deleted from the order. Since the matter is old one, last opportunity is granted so that any acceptable settlement can be arrived. If no settlement arises before the next date, the resolution plan will be heard for on merits. We are of the view that application for approval of the resolution plan, which has already been filed and pending consideration, the NCLT ought to have considered and decided the application for approval of the plan. It was also open for the adjudicating authority to consider IA 2594 and to take final decision. Plan have been approved on 8th Jan 23 and application is pending for about 1 year before the adjudicating authority. We are of that view that the adjudicating authority may proceed expeditiously to decide the application filed by the resolution professional to decide an application filed by RP for approval of the plan. It would also be open for the adjudicating authority to consider and decide IA 2594 filed by respondent 1. We are further of that view that the application which was filed by ex-director, where a proposal was submitted for settlement, the adjudicating authority ought to have given an opportunity to SRA to submit a response. So opportunity should be given to SRA to submit a response to the application, specifically when the applicant in his application has referred to various affidavit filed by SRA in the proceeding. The appellant in the appeal in the ground stands followed. In the impugned order has been passed without affording an opportunity to the appellant to file an appropriate response to the application, wherein the impugned order has been passed as the same as direct bearing on the resolution plan submitted by the appellant and prejudice the right of the appellant. In facts of the present case, we are of the view that the adjudicating authority ought to have allowed opportunity to SRA to respond the application which was made by the ex-director 188 of 24, whose resolution plan has been approved by the COC and which is pending for consideration before the adjudicating authority. Without giving an opportunity to the appellant, direction to the COC to consider the plan cannot be sustained. To obviate any further delay in the matter, we allow 2 weeks time to the appellant to file its objection in IA 188. The application for approval of the plan being pending consideration, it shall be open for the adjudicating authority to consider IA 188 of 24 along with the objection. In view of giving opportunity to the appellant to file objection to IA 188, we desist from entering into various issues which may arise for consideration by adjudicating authority. So here in this case, the simple order which was passed is the liberty was granted to appellant to file its objection to IA 188. But something which is going totally beyond my understanding is why third opportunity was given to ex-director with regards to proposal for settlement under 12A, when twice it was rejected by the COC in the past. So that is an order which is again passed by the Enclate New Delhi bench. If something is required to be discussed, we should discuss it first, and then we shall proceed further. We can able to cover one more judgment of the NCLT or the NCLT in the given time frame. Now, this is one of the case wherein the amount of advance was paid by the appellant for purchase of share of the CD, but it is provided that the same shall not fall under the definition of financial debt, as it was not disbursed again consideration for time value of money. But anyways, we will be taking care of this particular aspect in detail, that what was decided by the NCLT and what was the point of challenge before the NCLET. Section 7 application which was rejected, matter was referred before the NCLET. NCLET has rejected the appeal and upheld the decision which was taken by the NCLT Mumbai bench. I'm sharing the order of the NCLT first. It was before Mumbai bench court number 4. There are several facts which can be derived out of it. So it was a company application which was passed, which was made against 90 Properties Private Limited. That was Section 7 application, which was made. Just Share Realty Private Limited versus 90 Properties Private Limited. So corporate debtor against which Section 7 application, which is filed, not operational. So this is a company petition filed under Section 7 of the IBC by Just Share Realty Private Limited, the financial creditor seeking initiation of CIRP of the corporate debtor, which is 90 Properties Private Limited. The financial creditor is engaged in the business of developing and construction of the properties, and the corporate debtor was also engaged in the business of developing properties. Financial creditor agreed to purchase 100% of the share capital of the CD. Just take care of that, a certain limitation aspect which is involved. The financial creditor agreed to purchase 100% shares of the corporate debtor in consideration of 4 crore 50 lakh and paid an advance payment of 1 crore 25 lakh to the CD towards this transaction in year 2014. That was 17 December 2014. This fact is stated in demand notice dated 8th March 21, part 4 of the petition. The financial creditor has filed bank statement evidencing the payment having been made to the CD. On perusal of the financial statement of the CD for the year ended 31st March 18, it is observed that now CD has mentioned this amount as advance received from debtor. Advance received from debtor under the other current liability head. Thus, there is no dispute as to existence of debt. So that was the financial statement, and the entry in the financial statement, they have not shown as unsecured loan or pending application money, but they have mentioned advance from the debtor. The financial creditor has pleaded that the CD has failed and neglected to provide any document to advisor for carrying out the due diligence as mutually agreed at the time of entering into a transaction. So the financial creditor right now is alleging that the amount was paid in consideration of the share transfer, 100% share which the financial creditor, the so-called financial creditor, the financial creditor has made a contention that that amount of 1.25 crore was paid as an advance, in consideration of which the 100% share capital of the corporate debtor he was willing to acquire at a total consideration of 4 crore 50 lakh. The financial creditor has filed the letter dated 14th of November 2018 asking CD to pay the money within 7 days from the date of receipt in view of the non-resolution of the issue of title document and non-execution of share purchase agreement in relation to the share of the CD, meaning thereby there was no share purchase or share subscription agreement ever entered upon. The CD filed the affidavit in reply Feb 2022 denying the advance to the corporate debtor existence of any transaction for sale of share of the CD by its ex-director and existence of any share purchase or share subscription agreement. CD has also submitted that the petitioner is not a financial creditor as per the provisions of the code. From reading of the above definition of the financial debt, we find that amount of advance paid for purchase of the share of the CD does not fall under the definition of financial debt. But this was not the case. When we will be going to the appeal, we will be able to understand that this was not even the case. From the reading of the above definition, we find that the amount of advance paid for purchase of share of the CD does not fall within the definition of financial debt, as it was not disbursed against the consideration of time value of money. It is further noted that such advance also does not fall within the inclusive definition of the provision of section 5 subsection 8 of the code. Since the amount in default is not a financial debt, accordingly the applicant is not a financial creditor under 5.7 of the code. In view of this, the bench is of that view that the application is not maintainable. Under section 7 provides filing of an application by financial creditor only. So this was just an order with no great reasoning, but we can find much of the fact in the appeal which was preferred. Appeal was preferred by Joshia Realty, who was claiming itself to be the financial creditor before the NCLT Mumbai bench. I'm just sharing the order which was passed by the NCLAT in this connection. Now this is the NCLAT judgment. So Joshia Realty Private Limited, who once moved an application under section 7, but that section 7 application was rejected by the NCLT Mumbai bench, preferred an appeal before the NCLT principal bench at New Delhi. And this particular matter was decided by the NCLT, upheld the reason which was given by the NCLT Mumbai bench, but here there will be more clarity which will be reflected in this order, because it is not a pure case of an advance given against the shares. The present appeal filed under 61 of the code. The appellant has challenged the order dated Feb 3, 2023 passed by NCLT Mumbai bench 4, whereby learned NCLT has dismissed the petition filed by the appellant under section 7 of the code by observing that amount in default is not a financial debt and appellant is not a financial creditor. The fact of the case are that in December 14, just remember the date, December 14, Shri Shabir Nirban, director, shareholder and promoter of the respondent company, approached the appellant and offered to sell 100% share held with the respondent along with all the asset and liability of the respondent by executing a share purchase agreement which was not in existence. The appellant has further stated that based on the representation undertaking and assurance provided by the director of the company, respondent company, the appellant agreed to acquire all the asset and liability of the respondent as per the audited balance sheet March 13, after carrying out the valuation of the shares of the respondent for a lump sum consideration of 450 crore. That is 4 crore 50 lakh, sorry. The appellant has further stated that it has made an advance payment of 1 crore 25 lakh, but when the payment was made December 14, out of the total amount to be paid, that was 4 crore 50 lakh to respondent. and the said payment was made subject to execution of share purchase agreement after due diligence to be carried out by the appellant regarding asset, financial data and compliances. The respondent had at the time agreed to provide all the document to the appellant, and according to him the debt stand acknowledged as the same was reflected in the balance sheet, but in the balance sheet it was not reflected as an application money pending allotment, neither it was standing as unsecured loan, but it was standing as advance received from the debtor. The appellant has further stated that the respondent did not take necessary step as agreed between the parties, despite receiving payment of 1 crore 25 lakh in accordance with the promised agreement. In view of such situation, the appellant wrote many letter reminder to the respondent, calling upon it to forward the title document for due diligence, also to execute share purchase agreement without any delay, but no steps were taken by respondent despite remitted reminder. Hence, appellant asked respondent to refund the amount along with 18% interest. Appellant had added that when the said amount was not refunded, the appellant filed petition before NCLT Mumbai bench under 7. Appellant had submitted that the learned NCLT by impugned order has dismissed 7 application that amount in default is not a financial debt without giving any reasoning. The main issue that arises for adjudication in this appeal is whether an amount of 1 crore 25 lakh paid by appellant to Sri Shabir Nirban, ex-director of the respondent company, constitute a financial debt defined in IBC, and whether 7 applications filed regarding purported financial debt deserve to be admitted. We heard the oral argument advanced by the learned counsel. Learned counsel for the appellant submit that the appellant had contended in 7 applications that sum of 1 crore 25 lakh was advanced against the purchase of share of respondent company. He further argued that this advance paid by the appellant is reflected and admitted in the balance sheet of the respondent. But I said it was not reflected as application money pending allotment, or it was not reflected as unsecured loan, but it was reflected as an advance received from the debtor for financial year 14, 15, 15, 16, 16, 17, 17, 18, and 18, 19. And the advance has also been admitted in the pleadings of this appellant tribunal. He also submitted that the respondent in its reply before the adjudicating authority admitted that the transaction was made to purchase the real estate owned by the respondent. Learned counsel for the appellant has further submitted that in so far as 7 application being in limitation is concerned, the petition was filed on July 21, which was well within 3 years of the admission made in the balance sheet for a year ended on 19. Therefore, 7 application is within limitation in accordance with 18 of Limitation Act. Learned counsel for the appellant has also submitted that 5(8) of the IBC cover any amount paid in respect of share purchase agreement, and the definition is quite exhaustive. Please take care of it. This is not a case of share purchase agreement. He has claimed that here the contention of respondents are yet to come. He has claimed that this reason seemingly given by the adjudicating authority does not appear to be a valid ground in rejecting 7 applications. Furthermore, he has argued that whether the said transaction of 1.25 crore had commercial effect of borrowing was also required to be considered by the adjudicating authority to arrive at conclusion, but since it was not reasoned in the impugned order may be set aside. So that was a limited prayer of the appellant. Learned counsel for the appellant has cited the judgment of Sanjay D. Kakade versus HDFC Venture Trustee Company. The fact of this case was completely different. In this case, the existence of share purchase agreement was not in question. The learned counsel for the appellant has cited the judgment of this tribunal in the matter of Sanjay D. Kakade versus HDFC Venture Trustee Company. In reply, the learned counsel for the respondent has argued that the Section 7 application was filed by appellant does not make out the existence of any debt or default. Furthermore, he has argued that there is no agreement, written or oral, between the parties regarding debt, and therefore the learned adjudicating authority has given a correct finding that the amount claimed as purported debt is not a financial debt and dismissed the Section 7 application. He argued that the respondent has, in its detailed report before the learned adjudicating authority, brought out the correct fact with regards to transaction and has not made any admission regarding debt. In this connection, the council has referred to section 311, 312 and 58 of the IBC to explain that purported transaction between appellate and respondent is not covered under definition of financial debt and there is no default in repayment of debt. Now, this is very important. This is the fact, what the respondent has present. Clarifying about the nature of transaction between the appellate and respondent in regard to 1.25 crore, the counsel of the respondent has stated that the petitioner is the owner of immovable property being land bearing CS. This is Malabar Hill Division, so I'm not going into the address, but the building comprises of the tenanted premises. The property is situated in Teen Batti, Walkeshwar Road, Mumbai, very close to Governor of Mumbai's bungalow, near seafront. The building is capable of redevelopment under the provision of Development Control Regulation 33(7), under which the old tenanted building are permitted to be redeveloped with incentive FSI, and real value of the property given its development potential is more than 15 crore. The learned counsel for the respondent had further submitted that as per the scheme of redevelopment under the provision of Development Control Regulation, an existing tenant could get up to 35% additional area on ownership basis in new building to be constructed in place of old building. And with a view to encash this opportunity, the petitioner has approached Mr. Sabir Nirban, ex-director, ex-shareholder of the respondent company, to acquire tenancy right of the flat number 6 on third floor of A wing in the building. He further argued that with a view to acquire the tenancy right, the petitioner deposited 125 as advance out of 425 as a total consideration. He submitted that this is for his reason. The amount of 125 is shown as an advance from debtor in balance sheet of the respondent company. He added that thereafter the petitioner made no further payment and hence it is not entitled to make any claim against the respondent in view of its own default. He also argued that the value of tenanted premises is actually more than 450, as the petitioner would become entitled to receive an ownership flat with sea view of an area of 950 square feet, carpet on Walkeshwar Road, Mumbai. Therefore, the story padded by the appellant is a falsehood. Learned counsel for the respondent further submitted that even if at the highest argument, it is considered that the purported oral agreement existing between the Sabir Nirban, an ex-shareholder of the respondent company, and appellant to purchase the entire shareholding of the respondent in 14, the appellant had ought to have, now limitation point, appellant has ought to have sought the enforcement and specific performance of the same oral agreement within 3 years before December 17. Admittedly, the appellant requested the respondent for the first time in June 18 to execute the share purchase agreement. And even if one was to accept the argument of the appellant regarding existence of oral agreement regarding execution of purchase agreement is accepted, the said claim is barred by limitation. It was 2014 when the payment was made, and it was 2018 when the mail request was made to the respondent for execution of purchase agreement of shares. Learned counsel for the respondent had further argued that the appellant is using Section 7 petition as a tool for recovery of the time bar debt, which is not a debt. And certainly IBC is not mean for recovery of such debt. Therefore, even on this ground, the petition under 7 is correctly dismissed. Now, very important. Definition of debt and default, I'm not covering that. We now look at the transaction that took place between the appellant and Shri Sabir Nirban, 1.25 crore. The appellant has stated that in or about December 14, Shri Sabir Nirban approached the appellant and offered to sell 100% share held in the respondent company, along with all the assets and liability of the respondent. And based on the representation, undertaking, and assurances provided by the director of the respondent company, the appellant agreed to pay lump sum of 450 crore, that is 4.50 crore, after carrying out valuation of the share of the respondent. The appellant has further stated that in accordance with the oral agreement, he paid an advance of 1.25 crore by means of check drawn on HDFC Bank. He has further stated that the promised share purchase agreement was not executed, regarding which he sent a reminder to the respondent in January 18. The same thing he is placing before the Honorable Appellate Tribunal. Quite clearly, the appellant has not annexed any document relating. Now, this is very important. One cannot say that advance paid against the share shall not be considered as a financial debt, because in the Companies Act, there is a provision. Any amount which is paid as a share application money, the allotment is required to be made within 60 days. If the company fails to allot within 60 days, on expiry of 60 days, within 15 days, the amount has to be refunded. Otherwise, this amount shall be considered as a deposit. So one cannot take only the cover of the book into consideration. Quite clearly, the appellant has not annexed any document in this case relating to promised purchase agreement and only relied on the existence of the transaction of 1.25 crores in balance sheet of various year, and that too shown as an advance from a debtor. Therefore, the appellant has been able to establish that the said transaction was made with regards to future execution of purchase agreement. The only argument that the appellant makes in his favor regarding share purchase agreement is that he sent a reminder in Jan 18 to respondent to execute agreement. Such a communication made after a passage of 4 years, and that too regarding a promise made in 14, cannot taken as a conclusive proof of any oral agreement made in the year 13 or 14 for execution of purchase agreement. So it is not even a case of purchase agreement. Moreover, the definition of financial debt as enumerated in section 5.8 of the code is quite exhaustive and covered debt which were being made with interest disbursed against the consideration of time value of money. Clause A to I of 5.8 of the IBC do not state oral purchase agreement explicitly, but clause F states that any amount raised under any transaction, including any forward purchase or sell, having commercial effect of borrowing, could be considered as a financial debt. In the present case, neither 7 petition nor pleading or a document submitted by the appellant have any document to show that there was a share purchase agreement to be signed, nor any covered fact of the borrowing have been evidenced. In this situation, it is difficult to accept the contention of the appellant that transaction of 1.25 crore was in fact repayment of financial debt. Further, we note from the definition of debt and default as enumerated in 311.312 that financial debt had to be in shape of liability, and non-payment of such liability in the given time would cause default. If the present situation again, no date of default is made out, so we find that neither the state transaction is in the shape of financial debt nor commercial effect of borrowing is evidenced and no default has been made out. As argued by the learned counsel for the respondent and also admitted by the learned counsel for the appellant, the said transaction of 1.25 crore was ostensibly against the purchase of the shared property of Teen Bati, Walkeshwar Road, Mumbai, which was capable of redevelopment under the provision of Development Control Regulation. And it is provided specifically, therefore, and also because of this necessary under IBC to go into the nature of contract to see if the financial or operational debt, we do not consider it necessary to go into any further nature of the contract, whether written or otherwise, between two parties, to say that if the transaction was made in December 14 against a purchase of a specific property, the appellant should have asserted its right within the limitation period of 3 years, being the specific purchase of the contract. To try and enforce such contract through IBC does not appear to be the correct legal course of action. And now this point, which is making the things very clear, we also peruse the judgment in the matter of Sanjay D. Kakade versus HDFC Venture Trust Company Limited, cited by learned counsel for the appellant in support of its contention that the share purchase agreement and amount of transaction vis-a-vis such purported share purchase agreement would constitute a financial debt. We note that in this judgment, the tribunal has considered a written share subscription and shareholder agreement between the shareholder as a proof of financial debt. Quite obviously, there is a delay in signing of shareholder subscription agreement, which was in consideration of the said appeal. We therefore find that the ratio laid down in the matter of Sanjay D. Kakade versus HDFC Venture Trustee Company does not apply in the facts and circumstances of the present case. In view of the detailed discussion as outlined above, we do not think that the adjudicating authority has committed any error in dismissing Section 7 application. We concluded that the appeal is devoid of any merit and consequently it is dismissed, no order as to cost. So meaning thereby, this is not the case that amount paid as an advance against the share application money shall not be considered as a financial debt. Here the case was quite different. There was no subsistence or existence of any share purchase or share subscription agreement. It was mere a contention of the applicant, and the application was made under 7 as a financial debt or as a financial creditor. I would like to pause here. I would like to place the things before the forum now. In case if certain things requires a discussion or deliberation, we should keep the forum open for the next 10 minutes. And in case if any things are pertaining to the cases or the case laws which we have discussed, I would like to have my views on the same. I would like to again deliberate upon the same. I will keep the forum open for the further discussion for next 10 minutes. Yes. What I believe is, though we used to see that there are certain precedents, but the fact of the case here itself, we have seen in Ujas Energy, we have seen certain judgment which is passed by the NCLT Indore bench, vis-a-vis one of the order which was passed by the NCLT Mumbai bench. Now there was again contradictory view which was taken in that application, that the appeal which was preferred by Hari Babu Tota, and there was a Digambar judgment of the NCLAT, which is again contradictory in nature, but somewhere or other the facts are not the similar. And because of that, we cannot only, nowadays what we used to see is, just in order to summarily go through, or just in order to oversee or overview the order or the judgment passed by the NCLT, NCLAT, we generally refer to the articles, or we generally refers to the you can say citations of several authors. But when we deep dive into the entire copy of the judgment or the extract of the judgment, we find that the cover or the headings which is provided by the author do not have any relevance with its crux. So it is quite important that the entire judgment to be referred without giving any title to the subject, or without giving any title or subject to the story or to the narration or to the write-ups which are being placed in public forum. So I feel that the IBC is changing very frequently, is moving very frequently, and still the things are not much settled. As I mentioned about section 10A, wherein I feel that some clarity has to be placed before the stakeholder, either through some judgment of the Supreme Court or else by the ministry through some amendment or through some clarificatory order. And also, which I find very important, that is section 30 subsection 5, wherein I feel that if I, being a member of the COC as well as an applicant, a prospective resolution applicant, I always have some added advantage over the other resolution applicant who are not the member of the COC, and my voting shares are quite enough for either approving my own plan or else to disapprove or to be a roadblock for any other resolution plan. So I think the code is not completely settled, and there are contradictory judgments which are coming in, day out, but fact again are not the same in almost all the applications. I would like to invite your views. I would like to invite your opinions. I would like to invite your queries or questions in this connection. Other than that, there is no much sufficient time left as far as considering any another judgment or the order of NCLT or NCLT, which is left for discussion now. Thank you very much for the patience hearing. And I can
Thank
say
you,
that
sir.
it's always a pleasure to be a part of.
Thank you, sir.
Such
Very
forum.
great learning, sir. Great
Thanks a
learning.
lot, sir. Thank you
Thank
very
you
much,
so
sir.
much, sir.
It's always a pleasure on my side also to be a part of this discussion, because you all being a learned members, IPs, or practicing as a company secretaries or a chartered accountant or a cost accountant or an advocate. And I always appreciate in case if you have some contradictory views, the views which are taken by the tribunal or the appellate tribunal, but you are not in sync with the views which are taken. I appreciate your counters on the same. And yes, through such forum, it's always a brainstorming exercise, not only for the speaker, but also for the listener as well. So thank you very much, ICSI, for giving me an opportunity to represent or to present the thought process or the observation or the understanding, whatever this code has given through various judgment passed by NCLT, NCLAT, High Court and Supreme Court. Thank you very much.
Thank you very
Thank
much, sir, for such an informative session.
Sir, can you please provide your email ID so we will give you feedback and other information related to IBC?
I'll be sharing in chat box, sir.
Thank you, sir.
Thank you very much. Thanks a lot. Thank you very much.
Thank you very much, sir, for such an informative session.